All right. Hi, everyone. Welcome, welcome, welcome. Hope we had a good 2 days. You have a nice long weekend coming up. I said to the students before, I'll see you on Monday. They all start freaking out. Like, what are you on Monday? I'll see all of you on Wednesday after this. Let's see. Anybody have any questions? We had a very good class last time about Noel Canning, the recess appointment power, the removal power. Any questions? Anything on your mind? Anything lingering? What shtick?
The presentation that you were providing.
Oh, I have plenty of shtick.
Okay.
I have plenty of shtick. So the reason why is I do a lot of lecturing around the country on the ConLaw, but I love discussion, and I can't do a discussion in front of a very big group I don't know. So when I'm teaching you, I like discussing, asking lots of questions. When I'm in an unfamiliar crowd, I do straight up lecturing. Maybe once or twice this semester I'll do straight up lecturing, but I really disfavor it because the interaction, you learn more, I learn more, it's much more enjoyable. But eventually, when we do Obamacare, I'll do a little shtick for Obamacare, but that may be the only other time this semester. So I have some shtick to go. Any other questions? Any non-shtick questions? Or any speech shtick questions? I don't know. So today, our discussion is on foreign affairs, actually for today and for the next class as well as on foreign affairs. And this is a very difficult topic of constitutional law because the issue of war and foreign policy is something that most of us will never fully understand. And I don't say this in a political manner, but when decisions are made concerning war, foreign policy, foreign affairs, foreign relations, we have incomplete facts, right? We don't know everything that the government knows. And very often the government makes representations about the state of things, whether Japanese Americans are dangerous, or if that a steel mill is not seized, the entire war effort will happen, people will die. It's very easy for us to sit here in the 2015 and second guess those determinations, but at the time, it's not easy. In fact, it's almost impossible. And there's a very distinct role for the courts of how much scrutiny or how closely you're going to inspect the government's assertion that they need to do X because of some sort of need. So we have 3 cases today, probably one of which you've heard of, the other 2 probably haven't before this class. The first one is Curtiss-Wright. The second one is Dames and Moore versus Regan. And the third one is one that I'm sure you've probably all heard of in various respects, which is Korematsu versus United States. The first 2 cases try to analyze the scope of the president's war powers and how we can take action domestically based on those war powers. The final case, the Korematsu case, is a very difficult one to teach because it's so viscerally wrong. Yet the court doesn't seem troubled by what's actually going on. The final case asks, to what extent can the president use his military powers against civilians, right? It's not like you're prosecuting them in a federal court or you're saying you can't sue the Iranian government. It's actually throwing American citizens and locking them up in a concentration camp. Well, a very jam-packed case. Okay, so before I get started, I like relating the story. Justice Scalia gave an event a couple years ago in Hawaii, which has a very close connection to World War II because of Pearl Harbor. And a student asked him something like, "Could Korematsu ever happen again? Could it ever happen again?" And, we say, well, we're in the year 2015, we're enlightened, everything is great, but Justice Scalia said there's a maxim, a Latin maxim. I'll write it for you over here. It's in Latin. It says, intra armis silent legis, which roughly means in times of war, the laws fall silent. And Justice Scalia said this, and he said, Korematsu was wrong, of course, and the Supreme Court has basically ignored it. They repudiated it. But I'm going to quote him. He says, but you are kidding yourself if you think the same thing will happen again. You're kidding yourself. And it's been the history of civilization that in times of crisis, bad things can happen. Rahm Emanuel, President Obama's chief of staff, once said, a crisis is a terrible thing to waste. And that's a very apt expression. So in these sorts of war times, when the government says, if you don't do X, people will die, the usual sorts of sense and sensibilities fade very quickly. So I want you to keep in mind what Justice Scalia said, that there's no reason why Korematsu may not happen again. But the flip side to that is, and this is the harder one for you to do, it's very easy for you to say, oh my God, Korematsu, what a horrible decision, locking people up, bad, 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 bad. But I want you to force yourself to get into a frame of your mind of the alternative. You're a judge. You're not a general. You don't know what evidence the government has that may be classified about how American interests may be at risk. When the government tells you, if we don't do this, people will die, and you know if you say release Mr. Korematsu, that means you have to release another 100,000 people, Americans may die. Are you willing as a judge to let that happen? It's easy for us to say 60 years after that, oh my God, of course I would, right? But if you're in the middle of World War II, which in 1943, it wasn't clear, how that one was going to end. Maybe the Japanese were planning a land invasion of California. We don't know. So I want you to keep both of those schools of thought in your mind in this class and throughout the entire semester. On the one hand, does the rule of law fall silent in war? On the other hand, maybe courts should look a little bit less closely because of the war. And I'm not defending either position, but force yourself to think about it from both perspectives. It's so easy to beat up on Korematsu. It's like shooting fish in a barrel. But at the time, it may have been a much tougher call when you're in the middle of war and men and women being shipped overseas and people may be hurt domestically. Okay? Any questions before we get started? Good. So we begin with Article 2, Section 2, which I have up on the board. And this is more or less where the dialogue begins, right? Our Constitution separates powers. And powers over foreign affairs historically have been viewed as being vested in the president alone. Why? Well, we have this clause, right? The president is the commander-in-chief. He can make treaties with the consent of the Senate, and he can appoint ambassadors with the consent of the Senate. So while it's certainly true that in limited spheres the president has to share his power over foreign affairs, treaties he has to share the power, ambassadors he share the power, what about the commander-in-chief? Are there any qualifications to that? So textually, the answer here is no, that the commander-in-chief power is one he employs alone. But we know that's not true. Because what is the number one check Congress has in the president? The power of the purse. No matter what orders the president gives, unless his troops are being paid and his tanks are being gassed, they are not going anywhere. So indeed, Congress does have authority over foreign affairs. Okay? They can use money to raise and support armies. Without Congress funding, the president can't do anything. They can provide for a navy. And then there's this one. The power to declare war. The meaning of this provision isn't entirely clear. And let me give you the two different understandings. So the understanding you probably know is that unless Congress declares war, the president can't engage in war, right? The declaration of war actually gives the authority to the president to go and invade a country and blow stuff up, right? That's one interpretation, but that's not the only interpretation. Indeed, in 200 years of American history, we've had how many declared wars? 5. We've had a lot of presidents doing stuff on their own. We've only had 5 declared wars. So the other way of reading this, what does it mean for Congress to declare war? It's merely stating what's happening. We are not in a state of peace. We are in a state of war. And with that, there are a number of responsibilities under international law. But it's not entirely clear that the president needs congressional authorization to go to war. Again, this is a dispute. People do not agree on this. But for our purposes, the first interpretation controls, and Congress needs to vote to give the president the authority to engage in military action overseas. That's not necessarily the right answer, but that's the answer most people accept, so I'll assume it's true here. Okay. But that affects stuff overseas. What about when it involves Americans? So we already had one case like this, Youngstown, right? In Youngstown, President Truman says, I need to take the steel mills, because if I don't, our troops overseas won't have the materials and they'll die. Always, whenever the government has an answer, it's always people will die if we don't do X. They love that answer. But what happens if the president determines that Americans are actually helping people overseas? And if Americans help people overseas, it impacts our national interests. And this is the issue in United States versus Curtiss-Wright, the first case we have today. Curtiss-Wright is a manufacturer of different aircrafts and other military equipment. And during the 1930s, there was a war called the Chaco War. Has anyone ever read about this or know about it? Anyone know anything more than the book said? Okay. This was effectively a war between Paraguay and Bolivia. The reason is they suspected there was oil in the region. And whenever people think there's oil, people start fighting over land claims, right? But the problem with these sorts of war is that the United States doesn't really favor one side over the other, right? They don't really know who to support. So in this case, the president said, you know what? We're not going to support either side. But military companies that sell military equipment, they see a war and they think, aha, cha-ching, cha-ching, right? Let's sell guns to one side or the other. It doesn't really matter which side. And that way we can make some money. So we have 2 acts that I want to focus on. So initially, Congress enacted something called a joint resolution. This is super duper extra credit. Who remembers where in the Constitution we discussed resolutions? Anyone? This one's tough. We mentioned it. I think I mentioned at least once. Not a treaty.
It was where where Madison talked about how whatever you call it, it's a bill, whether it's resolution or
Yes.
anything else.
Thank you. Bingo. Extra credit, right? Article 1, Section 7. This was a provision we discussed with Chadha and Clinton, right? Bicameralism and presentment. Everything must pass both houses and go to the president. And the Constitution says, as Caleb mentioned a moment ago, every order, resolution, or vote, it doesn't matter what you call it. You call it a resolution, you call it a vote, you call it a bill, doesn't matter. Both houses have to sign it, and then it goes on to the president. Okay? So Congress passed a joint resolution, and I'm going to show it to you. It wasn't, I don't think it was in your book, but I dug it up. And the purpose of this resolution, and the green highlight language is the relevant one, the purpose of this resolution was to address what was going on in the Chaco War. So it says, the president makes a proclamation that it shall be unlawful to sell arms to the countries now engaged in an armed conflict. So basically, Congress created a resolution. It did not criminalize the sale of arms to those countries. What it said is that when the president makes a proclamation, at that point, the act becomes illegal. Now, where was that up to going around? What did I finish saying? Debbie, why do you think that Congress would do that, right? Why wouldn't Congress just say, period? You cannot sell arms to Paraguay and Bolivia, period. Why would they do this thing where it only becomes a crime when the president says so?
I think because they wanted commerce to align with the policy of the country. Rather than being specific to Paraguay and Bolivia, they wanted the more general rule.
Very good. So Congress basically said, listen, we don't think we have enough knowledge over foreign powers to decide this. We're going to let the president decide which countries will be subject to this ban and also when this will go into effect, right? We don't want to tie the president's hands. So everyone see what they tried to do. Marco, based on what we discussed before, what's problematic about this sort of a resolution? And think very specifically about Clinton v. City of New York. What's the problem with this sort of resolution? But let's go back. What was the problem in Clinton v. City of New York, the line item veto case? What was problematic there?
That's when Congress delegated the power, or wanted to delegate the power to the executive branch. And therefore, if the executive branch did something that Congress didn't like, then it would have to go back.
You gave me the beautiful word, which was delegation, right? So recall the line item veto worked like this. The House votes on it, the Senate votes on it, the president signs it, and then cancels stuff, right? And the court said, no, 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 no. You have one option. You can sign it or veto it. None of this cancellation business, right? Marco, when the president gets this joint resolution, what does he do with it? Yeah, what are his options?
He can sign it or not sign it.
But after he signs it, what does he have to specify to the question raised before by Debbie? It's not enough to sign it. What does he have to specify?
When it comes into effect.
Yeah. And I'll give you a hint. Here it just says the countries. What does he have to specify? Which countries, right? So this isn't a case where the president signs whatever comes to him. It's some weird hybrid. And I'll show you what President Roosevelt actually proclaimed. This is what he said. He didn't sign it. He said, I do hereby admonish all citizens of the United States to abstain selling arms to Bolivia and Paraguay. And I warn you that you'll be prosecuted for it. So this isn't a case where the president just signed the bill. He actually augmented it. He added onto it. He made all these other provisions which Congress never voted on. And Marco, what's the problem with that?
The power that the president has is either to sign or not.
Yes. Right. So the problem here, again, is our favorite non-delegation doctrine, right? Which is in every case, but never, it's referenced very briefly if you noticed it. Effectively, Congress gave the president the power to make a law, that he could choose which countries and how to enforce it. Understandably, Congress didn't want to tie the president's hands, but that's not a power Congress has. So what's curious is the name of this case is, Walter, let's ask you this question. The name of this case is United States versus Curtiss-Wright. What happened in the lower court? Without knowing anything else. The name of the case is United States versus Curtiss-Wright. What happened in the lower court? Don't look at your book. It's not in your book. The name of the case is United States versus Curtiss-Wright. What happened in the lower court? Who lost? Don't help him. Why? No, I don't. I'm giving you only the name of the case.
Okay.
Whose name comes first?
United States.
Who lost in the lower court?
United States.
How do you know that?
Because they're appealing these decisions.
Yes, everyone knows this, right? The name that comes first is the party that's appealing. The name that comes first is the party that lost. The United States lost in the lower court. Remarkably, the judge in the Southern District of New York in Manhattan ruled against the government under the non-delegation doctrine. I had to look it up. That wasn't in the book, really. Okay? It was mentioned, but it wasn't really discussed. That's how the court was ruled below. So the question in this case was, on the lower court at least, could Congress give the president this kind of authority? Could Congress delegate to this president the authority of making these sorts of determinations? Okay? That is not how the Supreme Court resolved it, though. The Supreme Court did not resolve whether Congress could delegate that authority. Mark, why did the court not need to decide if Congress could delegate this authority? What was the basis for the president's power? Not a statute, but
The resolution?
what was the basis for the president's authority? It was not something from Congress. Think back to Youngstown, right? What are the possible bases for authority when the president acts? There's two.
There's in times of
No. What are the possible bases of authority for the president to act? There's two answers. Kind of. Generally speaking, when the president acts, on what basis does he act? What's he executing?
he's executing the law.
Who enacted that law?
Congress.
Good. So the first, right? The president can act on the basis of statutes. Remember, on the basis of statutory authority. Or, Mark, what's the other basis in which he can act?
To execute the law that's already there.
You're running around the question. What is one of the other bases in which the president can act? It's such an easy answer. I'm going to.
When it's necessary and proper.
That's Article 1. Which articles for the president? So you answered your question. On what basis can the president act if it's not statutory? The Constitution, yes. Article 2, Section 2, right? The president gets authority, as I said in Youngstown, from either a statute or the Constitution itself. He gets authority from the statute or the Constitution itself. So the question in this case wasn't whether Congress gave him the authority. The question is whether the Constitution gave him this authority. Everyone with me so far, right? So, Yvette, let me ask you this question. Is there any clause in the Constitution that says the president gets to decide who to prosecute for selling guns to Bolivia? Is that a clause in the Constitution? Okay, so then where can we find in the Constitution this sort of authority? Let me ask you the question differently. If the power is not express, what kind of power may it be? Implied. Good. What's implied power mean? Ha! Yeah, I knew you were going to say that. Where do we get it from? How do we understand there's an implied power? What does that mean? You're on the right track. Yeah. So we have these clauses in the Constitution that don't really specify exactly. So we have the president shall be the commander-in-chief, right? We have another clause. We have another clause. Second. The executive power shall be vested in the president, right? We have all of these clauses which say the president has powers which are not defined, okay? He has the power to receive ambassadors, right? He has all of these powers that relate to foreign policy, okay? Aaron, how does the court understand the scope of the president's powers over foreign policy?
State executive over all foreign affairs.
Okay, and where does he get this authority from?
The Constitution itself, whenever it talks about implicitly how he receives ambassadors, public
Good.
ministers,
Good.
It gives them the power to have the cabinet. The cabinet for the U.S. State Department actually works in foreign affairs.
Yes. Basically, the court says like this. The president has inherent power, or implied power, to use Yvette's phrase, implied or inherent powers over foreign affairs. We get this from the entire document. He can receive ambassadors. He can appoint ambassadors. He's the commander-in-chief, right? There are all these different clauses which basically picture of the president as having authority over foreign affairs. Everyone with me? And the court uses this phrase. The president is, quote, the sole organ of the nation with respect to foreign affairs. The sole organ. Johnny, what's that mean, the sole organ of foreign affairs?
Like he's the only representative to other countries. He's the
Yeah.
sole.
What's organ mean? What is that like? You know, keep it clean.
Operation.
Yeah, the sole voice, right? The idea is the United States speaks with one voice. It's not 535 members of Congress yap off. It's one president speaks with one voice for foreign affairs. Okay. Naquanda, is that right though? Is it right that the president can speak with one voice to the world?
Yes, because it means the decisions he makes is going to be one decision and it's not going to be all these different opinions.
But doesn't the Constitution put a check on the president's foreign affairs powers? Several, maybe.
I don't think it will.
You tell me. What checks do the Constitution place for the president's foreign affairs powers?
In terms of war,
Sure.
that Congress has to pay for it and Congress has to declare war.
Yeah. What else? What else could the president need Congress permission to do foreign affairs?
I'm not sure.
You want to take a stab, Amanda? What else?
You mean like, the advice and consent?
Yeah. Advice consent for what? To do what? Yes, treaties, right? If the president wants to engage in a treaty with a foreign nation, he needs the advice and consent of the Senate. And actually, it's not advice and consent. To be precise, it's 2/3 vote. He needs advice and consent to confirm ambassadors. So you need a majority vote to appoint an ambassador, and you need a 2/3 vote to approve a treaty. So the court in Curtiss-Wright takes a very robust, broad view of executive power, right? It says the president is the sole organ of foreign affairs. And actually, that quote, sole organ, who actually said it? Anyone pick this up in the reading? Who said sole organ? Marshall. Our good friend John Marshall comes back to haunt us again, right? This phrase sole organ comes from Marshall, not from Madison, which I think is indicative. But the court says, in matters of foreign affair, it's up to the president. Okay? So what's actually kind of weird here is effectively the court said the president can make something that looks like a statute based on his foreign affairs powers, right? Even though Congress didn't give him the authority to prosecute this company, the president could do it by himself because of the war powers. The court didn't say that expressly, but that's the implied intent, right? You can throw someone in jail, even in the absence of a statute saying so. It's a very weird holding. And I want you to pay attention. Next week, you have Zivotofsky to read. That's a big case, so make sure you give yourselves time to read it. The Zivotofsky court severely limits Curtiss-Wright 80 years later. So pay attention to that when you read Zivotofsky. Okay, so any questions on Curtiss-Wright? Yes, sir.
You said that the court gave or acknowledged the president's powers in foreign affairs, but the case is 1936, I think, what, 12 years earlier, the Senate didn't let us join League of Nations that the president actually created a side treaty.
Yeah.
So wouldn't they kind of look at that and say the legislature didn't want this, or the Constitution did?
Well, let me ask you this question, Nuri. It's a good question, right? When Congress passed this resolution, they had it on the screen before, right? What do you think Congress was saying to the president?
It's only a problem.
Do whatever you want. Yeah. So you're right. In other instances, Congress wasn't so cheerful. But here, the president and Congress agreed. And what happens when the president and Congress line up? How do we view that question?
President has the most leeway.
And a court's going to get in the way? That is also, Youngstown hadn't happened yet. Youngstown will come 15 years later. But here, it's fairly obvious to the court the president and Congress agree, so they're not going to get in the way. They're not going to second guess. Your hand? Yes, sir.
Just to make sure I'm on the right track. Ultimately, the court makes this decision, basically approving this communication between Congress and the president by saying that even though it's an American company, it has to do with foreign nations.
Yes.
Right. So that's kind of why they say that the president has that power, and why it's delegable by Congress for him to say.
Not that it's delegable. It comes from the Constitution itself.
Okay. Okay.
They're
not dealing with the delegability at all.
No, because it comes straight from the Constitution.
Okay.
In other words, because the president's power of foreign affairs is so strong, he can basically prosecute this company. Now, this was hinted if this was a purely domestic matter, right? If the resolution said the president can prosecute any state in the country, per people in any state with that specificity, that would not be constitutional under the delegation doctrine. It's a weird case, and again, when you read Zivotofsky, thankfully they peeled this case back. Some of an outlier.
That's it.
Yes, please.
Are you saying then that he really didn't need the joint resolution? He could find straight from the Constitution.
That's what the court's suggesting. The court is suggesting that, yes, but they don't say that outright. But that's a suggestion.
And because this was a foreign issue, more than likely the court would have still allowed it. Not as if this
Yeah.
was
So Michelle, how do you reconcile this with Youngstown?
Yeah, well,
Youngstown, they said the president can't make up a statute, and they can't decide to seize things. That's a congressional decision.
I personally think SCOTUS saw this, it was just too close to home. It was our civil liberty, our liberty was at stake, but it's not providing separation of powers.
Yeah.
And because this was a homegrown issue, meaning it was a domestic issue, I think at that point they said, no. Now, if that has been something overseas, I think.
Yeah, I mean, this is a case that executive branch lawyers, like the president's lawyers, love this case. Because I'll tell you, on my exam, everyone will write sole organ. They'll be all over the exam, right? But I want you to pay attention to the other cases that come after, because this is like the broadest stretch of executive power, but it gets a little bit more cramped as the years go on. Any other questions on Curtiss-Wright? So did anyone see the movie Argo?
Yes. Yeah.
And I'll say it. So this was a good movie. It discusses the Iranian hostage crisis. And the premise was like this, right? So I'm sure many of you probably know. In 1979, the American embassy in Tehran was captured. And there were a number of people working at the American embassy who were U.S. citizens who could not escape. And they were basically held as hostages until, was it January 19th, 1981. Basically, on the eve of the inauguration of President Reagan, the hostages were let go. But during this period, it was very scary because it was basically being held by the Iranians. And indeed, Mahmoud Ahmadinejad, the former Iranian president, was one of the terrorists who captured the State Department workers. So why is this relevant? Okay, so we had a deal with Iran, not the one today. We had one in 1981. And basically said, okay, our countries are going to still hate each other for a while, but we're going to at least try and make things not so bad. And one of the ways you make things between countries not so bad is by settling disputes. So Iran's a country. They were, believe it or not, trying to build a nuclear program back in the 70s, and they contracted with an American company. The name of the company was Dames and Moore. Okay, they basically signed a contract with Dames and Moore to provide some services related to their atomic energy program. Peaceful, I'm sure, peaceful. After this entire blow-up, unsurprisingly, Iran didn't pay their bills. And like any company, when they don't pay their bills, what do? You sue them. Iran didn't answer the lawsuit. Okay, so what happens when you sue a company and you get a judgment against them? You try to seize their property. Okay, so Dames and Moore was able to sue, and they got a court judgment to seize their property. But then a problem intervened. In order to resolve all the disputes between Iran and America, the President of the United States, not Congress, but the President of the United States, both Reagan and Carter, signed an executive order. And this executive order said, we will suspend all lawsuits against the Iranian government and force people to go to this claims tribunal where they can go to get money but not from a federal court. Right? Renee, why do you think the president suspended all lawsuits against Iran and said go to this tribunal? What do you think the purpose was there was? Yeah, it's to eliminate what's called friction, right? If there are all these lawsuits pending against the Iranian government, that gets in the way of the American country building relations with Iran, right? But the flip side of that, Renee, is what happens if you have a lawsuit pending in a federal court and the government just canceled, and the president's executive order just canceled your lawsuit? What do you think you're going to feel? Yeah, why are you going to feel bad? And do you think you'll get a penny from this claims tribunal? No. Okay, so here's the rub. If you had a lawsuit pending in federal court against the Iranian government, after President Reagan's executive order, you no longer have a lawsuit in federal court. You're transferred to this special tribunal. By the way, the name of the case is Damsel versus Regan, not Reagan, but Regan. And this was the Secretary of the Treasury, Thomas Regan. People have been confused that. So it wasn't against the Gipper. So, you okay, Janine? Okay, Janine, what do you think there's a problem with the president canceling your lawsuit? What do you think is problematic about that? Putting aside anything you learned today, but generally, what's the problem with the president canceling your lawsuit?
That's going a little bit beyond his powers.
Why?
You can't personally tell me as civil citizen to do something, or that I can't not do something.
Who can modify the jurisdiction of the courts, Janine? Which branch of government?
The legislature.
Yeah. So this may strike you as shocking, but it's true. The legislature can modify the jurisdiction of the courts. If the legislature was insistent, they could pass a bill saying the federal courts no longer have any jurisdiction against cases against Iran. Is there anything wrong with that, Janine? Could they do that?
I'm sorry, repeat.
Could Congress pass a statute saying federal courts no longer have jurisdiction against the Iranian government? You cannot sue the Iranian government in a federal court.
Yes, courts could do that.
Yeah, they could do that. I mean, it would be a weird thing to do, but they could do that. Janine, does the president have the power to suspend jurisdiction over claims?
No.
He does not. So the question here becomes, did President Reagan, and Carter did the same, have the authority to enact the executive order that suspended all of these lawsuits? Did everyone get the question? Cameron, so I asked this question to Mark a minute ago. I'll ask you the same question. What are the two possible sources of authority for the president to act? There's two possible sources of authority.
Statute and Constitution.
Thank you. Exactly right. Statutory authority and presidential authority. And Cameron, for a moment, think back to Youngstown, right? Do you remember how President Truman justified his action? Did he think he was relying on the statute or the Constitution or both? How was he acting? Do you remember?
He was saying it was necessary to
Which of the two authorities was he relying on?
Constitution.
Yeah, so if you remember back in Youngstown, President Truman said, I'm relying on the Constitution. And the court said, this is not foreign affairs. Remember that part, right? They said, even though this affects the war, you are seizing a steel mill in Ohio. So Cameron, do you think here the president can rely on purely foreign affairs to suspend a judgment in a California court?
It's a better argument because it's a lawsuit with a foreign
Ooh,
government.
good. That's a good argument. But do you think the court's going to buy a pure executive power argument here? So if we're not looking to the Constitution, what do we look to?
Statute.
Okay. And this is where we get to Youngstown. So I think I mentioned this before, but this is a very cool historical fact. The leading opinion, of course, in Youngstown was authored by this man, Robert Jackson. He wasn't the majority opinion, but his concurring opinion is viewed as the definitive statement of the separation of powers. And you recall that Jackson said, you have to look at how closely aligned are Congress and the president. Has Congress authorized this sort of action before? So who remembers, who was the law clerk for Robert Jackson the term Youngstown was decided? William Rehnquist. Okay. This guy. Who remembers this one? Who was the law clerk for William Rehnquist the term Dames and Moore was decided? John Roberts, this cute little guy right here, right? The piercing blue eyes. This is just too freaky for my mind, right? Robert Jackson, the justice, had Rehnquist as a clerk for Youngstown. And the case was not brought to the court again until Dames and Moore, when Rehnquist wrote the majority opinion by a law clerk named John Roberts. And then Roberts went to interpret Youngstown in later cases. Weird stuff, but kind of a fluke. And the timing of this case is insane. Basically, the case was argued on June 24th. It was decided on July 2nd. So in 8 days, the entire case was over and done. And by the way, unanimous opinion. This is not like Youngstown with like 5 or 6 different opinions, right? This was unanimous. And if I had to bet money, John Roberts wrote it. So actually, I Googled this. The other clerk, one was a very popular plaintiff's attorney, did personal injury work. The other one did some sort of financial work. So Roberts obviously went on to the highest heights. Okay. So we have the question, right? Did Congress provide statutory authority to President Reagan to suspend the judgments? Okay. So you'll recall, Roy, in Youngstown, Jackson went like this. Like, listen, the president had asked for the power to seize steel mills, right? And Congress said no. Based on that, how did Jackson rule?
It would have the weakest.
Yeah. So Roy, let me ask you this question. Citing Youngstown, right? Is there actually direct statutory authorization for this case? Did Congress ever pass a statute saying the president could suspend claims in federal courts?
No.
There's not. Okay. So shouldn't that be the end of the story under Jackson's framework?
Perhaps, but they expounded upon it.
Oh, I like how you phrase it. So if Justice Jackson, not his lazy law clerk, right? But if the original Justice Jackson was still in the court, how do you think he would have understood this case?
He would probably advise against doing it.
Yeah. And this is something that's often difficult to understand. Dames and Moore altered Youngstown, and it did it in a very subtle but significant way. Youngstown basically said we look to whether Congress and the president are at the same level, and we look to whether there's any sort of direct statutory authorization. In this case, there really isn't. Congress have been silent. Maybe you get yourselves into the zone of twilight, right? And then you're in the zone of twilight. Maybe it goes one way, maybe it goes the other. But Rehnquist does something else, right? How does Rehnquist, Jared, go through the history of statutes to try and find support for what the president did? What does he look at?
Well, doesn't he pretty much say that you never know really what's going to happen? So you have to
Yes, but what does he look at? There's no direct statutory authority on here, right? So what does he look at to get there?
does he look at if it's an emergency? Like
No, I'm asking specifically which laws does he look at? It's a very specific question.
just,
They're named.
talking about the hostage act?
Yeah, good, okay. So he says, listen, there's no statutory authority directly on point, right? There's no statute specifically giving the president this power. But there are these two sources of authority, what's called IEPA, which I love, right? The International Emergency Economic Powers Act, another law called the Hostage Act, okay? neither of these laws gives the president the power that he seeks, right? IEPA authorizes the suspension of claims in a totally different context, not here. And the Hostage Act gives similar authority in different contexts, right? Rehnquist then says something very important. He says, both statutes, quote, are highly relevant in the looser sense of indicating congressional acceptance. Let me say that one more time. Both statutes are highly relevant in the looser sense of indicating congressional acceptance. Okay? Nikolai, what does that mean in the looser sense of indicating congressional acceptance?
It means that while Congress hadn't directly given its acceptance in this particular case, they probably would have done it.
Yeah.
Or that it says it later. Congress can't give.
Very good. Very, very exactly right. What Rehnquist is saying here is, it's true. Congress has not spoken to this issue, but in related contexts elsewhere, right? In different contexts that are somewhat similar, Congress has given the president this authority. And it's from this related authority that Rehnquist says there is sufficient delegation. So, Toshiba, in Rehnquist's mind, are we in the zone of twilight here? Where are we? Which tier of Youngstown are we in?
I'm sorry.
According to Rehnquist, which tier of Youngstown are we in? Are we in the zone of twilight? Is this ambiguous for him?
First.
Yeah, exactly right. We're in number one here. He doesn't exactly say that directly, but to Rehnquist, we are in the first tier of Youngstown. Why, Toshiba? Why are we in the first tier?
They, even though they did not expressly agree, he's looking at history to say that they would agree.
Yeah,
We're in the first.
but looking to practice, right? Past practice. And now you see what I'm saying, where they kind of altered Youngstown, right? Jackson's inquiry wasn't this flexible. Jackson said, listen, let's look at reality. Let's look what happened. If there's no authority, the president loses, as Lois said. Rehnquist's like, let's not be so, stingy. Like, let's not be so cheap. If Congress has given this authority in a related context, we should assume they would give it here. Let's see this. Jennifer, what's the problem with that line of reasoning? Why is that problematic? Yes. This is expressio unius, right? If Congress gave the power here and not there, what's the inference we draw? No. If Congress gave the power for this context, but they withheld it for the other context, what's the inference that we draw? Yeah, that Congress deliberately withheld it. So while Rehnquist says, if they gave this authority here and not there, I say, if they gave it here, they withheld it there. It was a deliberate action. So what Rehnquist basically does is he inverts Youngstown slightly, but significantly. The fact that Congress ruled in similar areas and gave this authority, Rehnquist sees is evidence that they would have supported this action. That they would have supported this action. He looks at this long-standing practice and says, based on this practice, what I call acquiescence, right? That Congress has acquiesced to suspension of claims, therefore they would likely support this as well. Is your hand up? Okay. Raise your hand.
If this had not been such a time issue.
Oh, you tell me the time, right?
8 days.
Yeah.
Let's say this was some long protracted negotiation going on. Do you think Rehnquist would have then said, President, you need to go back and talk to Congress?
Well, what did he say at the very end of the opinion, Michelle? At the very end, right? Had Congress objected to this settlement after it was signed? Has Congress voiced any opposition to it?
No.
They haven't. What have they actually done?
They basically, they're waiting to after the fact to just say, we would have agreed. We were okay with it. Is that what you're asking me?
Close. What did members of Congress actually say about this deal after the fact? Were they happy about it? Caleb?
To say that, even though there's displeasure with the agreement, it is of vital importance to the United States.
Yeah.
So it's better to clear this up and go our separate ways with Iran than to keep this going.
Has Congress tried to defund this?
No.
Has Congress tried to issue a proclamation in opposition to this deal? Rehnquist looked at the list, and Congress had a chance to say something about it, but they've been silent. This post-ratification silence means Congress isn't really opposed to it. So, Michelle, your answer also is another layer of Youngstown, right? Toshiba said we're at level 1. Yeah, because Congress's silence means they're not opposed to it. See, he's basically like rejiggering the tiers.
Is he getting there because Congress has had opportunity to say something
Yes,
about
and
it
they did nothing.
and choosing not to?
Yeah.
Is that kind of how he's
Yeah.
squeaking by there? At
And
the
does this remind you of Youngstown? Because after Truman seized the mills, Congress was silent.
Yeah.
Shouldn't this be, if they're silent, it doesn't mean acceptance?
I mean, but it's just because they have opportunity to say
Yeah.
something, and so that's how he's inverting that expressio unius
Exactly right.
maxim, right?
And again, this is a reversal of Youngstown, because in Youngstown, the fact that Congress was silent did not mean they accepted it.
Right.
You see, Rehnquist is not a very good clerk. In fact, he spoke very poorly of Justice Jackson, and he wrote critically of him. He actually wrote a memo saying how the Youngstown case was terrible. He never liked it. Aaron.
I'm still trying to understand the distinguishing factor because in Youngstown, the president actually sent several messages to Congress.
Didn't he? Yeah.
Over a 9-day period.
Yeah, and that wasn't enough.
I'm doing this, I'm doing this, I'm doing this. It's still silence.
And the silence was not enough for acceptance, was it? In Youngstown.
So, other than Rehnquist hates Jackson, what is the distinguishing factor?
So I think again, it's a fair question, and I don't know if I have a good answer, but I think one answer is this actually was a foreign affairs matter, right? I think someone said it before. Youngstown was viewed purely domestic. Here, we're directly suing a foreign belligerent. We're directly suing a foreign nation. And I think the fact that it was a foreign affairs power amplified the president's authority, right? It wasn't a purely, it wasn't like Curtiss-Wright where he had the authority straight from the Constitution, but his powers of foreign affairs amplify his domestic powers. I think that's what's lurking in the background.
It's still having, so you have steel plants in the U.S., but the issue is that you have essentially a U.S. company, which is economics, being told that they can't do an economic activity, but a steel mill can do an economic activity.
Distinction isn't strong. And one of the dangerous parts about law school exams is people say, oh, Youngstown, but Dames and Moore altered it in a significant way. People love to profess fidelity to Jackson, but Rehnquist's opinion has a lot more in common with the dissents. Yes.
Well, this opinion may put a little bit back more on Congress and their lack of taking a stand.
Yeah,
because,
if Congress didn't stand up, why should the courts?
yeah, and if they don't do something, if they don't allow it, if they would have stood up and said no, and it results in an all-out war between Iraq and the U.S., Iran and the U.S., the Congress didn't want to be held to that kind of standard. I'm guessing why they never, or maybe part of their thinking. So
Listen.
maybe Rehnquist is kind of calling them out on that you need to put your money where your mouth is.
I mean, history repeats itself, right? So in this world today, we have a deal with Iran, right? And the Senate is about to vote for it. And in the event that the Senate votes down the deal with Iran, the president will likely veto it. He will veto it. What does it say about a foreign policy agreement that the president has to override it? That's a veto, that the people don't agree with it. I'll give you another example. So after the president engaged in DAPA, which is Deferred Action for Parents of Americans, Executive Action Immigration, both houses of Congress passed resolutions opposing it. So if there were questions about the scope of the president's executive powers, those resolutions would indicate that Congress is not in line with them. Congress considered defunding DHS over those actions, but they didn't because that would shut down significant portions of the government. Did the fact that Congress funded DHS then show that they now acquiesced to it? Welcome to my world. This is a question I grapple with every day, but it's a legitimate question when you go ahead and fund something, right? Or you don't oppose it. Under Rehnquist's analysis, you just accepted it. By not actively opposing it, you're now in bed with it.
I thought maybe this case was a product of its time, kind of Korematsu.
Like his tie?
Yes, sir, because
Sorry. Rehnquist was a very flamboyant dresser. I'm being mean. He's at one point he saw an opera where the judge had these golden stripes on his robes. He had gold stripes added to a Supreme Court robe. He was kind of an eccentric. Anyway, proceed.
I thought there was an embarrassing rescue attempt that failed. I believe they sent Delta Force out.
Oh, I mean, it was an epic failure. Yeah, I mean, Jimmy Carter tried to have the. If you see the movie Argo, you'll see that. But they tried to rescue the captives, and it was an epic. It was bad. I want to show you a good picture of Rehnquist with this. Okay, here it is. So this is what Rehnquist. Oh, I get you a better picture. He was a. Oh, here we go. This is what Rehnquist looked like when he first got appointed to the Supreme Court. He cleaned up a bit. Yeah, he had the sideburns, the huge ties. I mean, you can't tell. It's a bad picture. The sideburns are down all the way to his face. Don't laugh. It was the 70s. What did Rob Williams say? It says, if you remember the 70s, you weren't there. Anyway, I don't. So, anyway. So the case itself, though, is narrow, though. If you notice at the end, he says, we want to emphasize why this is so narrow, right? We're not saying the president has unlimited power to suspend claims, but where there's some sort of authority we can get, you know, and we can read it in statutes, we'll give it to the president. And he says, he finds 4 facts, right? He says, the character of the legislation Congress enacted, IEPA, the Hostage Act, and acquiescence in other sorts of executive settlement claims, the president can do it. And in fact, if you notice, he cites Justice Frankfurter, not Jackson, saying that if there's an unbroken practice that was never challenged by Congress, that's actually an additional executive power. When there's an unbroken practice that Congress never challenges, hey, who are the courts to stop it? It's not unprecedented. It's been done before. Unanimous. In 8 days, too.
Okay, I have a question. I keep forgetting it. Sorry.
Want to come back? You come back. I'll call on him. I'll come back to you in a minute, okay? Try and think of it. Yes, sir.
Okay, so I see that time period's 1981. And I don't remember who said it, the judiciary, but essentially they made an argument for the president about the will of the people. I believe it was one of the dissents. And since Rehnquist is using some of the dissents or opinions in this case, are we looking at essentially the overwhelming victory of Reagan from 1980, maybe playing a factor in it?
Not really. I think I think to the extent this was a product of its time, they realized that if these claims were not suspended, it would have significantly screwed up our foreign relations with Iran, and Ayatollah could have went and backed out of the deal. Right? I mean, what could the court have said? Congress go pass a statute authorizing suspension of claims, and that would have been passed in 5 seconds. Right? The court could have said, Congress go pass a statute authorizing suspension, that would have been done in 5 seconds.
Yeah, we wanted our hostages home.
Well, they were home at this point.
Well, no, I'm talking about that year, the span of time, every day. I can remember I was in college. Every day they were showing pictures of our hostages.
Go watch the movie Argo. It's a good movie and it captures it well.
People were very frustrated.
Mark, yeah? Remember your question, Michelle?
Yeah, I did.
Go.
So does this, what he did to Youngstown, Rehnquist, did it then change that tier 1 then became larger and then shrunk the Twilight Zone?
That's one way of looking at it, right? Because he never
eliminate
acknowledges altering it, right? He never says he is, but as our discussion revealed, it ain't the same. And since this case, there hasn't been a straight-up Youngstown case. The Guantanamo case is indirectly, right? Because in most cases, the president had authority from the statute and the Constitution. So we actually haven't had a straight-up Youngstown case since then. But Rehnquist definitely tweaked his boss's handiwork. Yes, sir.
do you think in Youngstown, I think I remember a line in Youngstown about them saying that seizing the steel mill was essentially moving into, nationalism.
Mm-hmm.
So do you think that maybe in that particular case, they were like, look, if we let it happen here, specifically by seizing this steel mill, it moves to nationalism, then it's going to start moving to other industries, as opposed to here.
What's the risk? Yeah, I mean, I think Mark raises a good point. The president could seize the steel mills. Maybe he could seize, the iron factories, right? He could start seizing, coal mines, right? Here, they're suspending lawsuits. Are they going to do that all the time? Probably not. And this type of thing only happens when you have a foreign policy dispute. All right, any other questions on Dames and Moore? So the chief's opinion reads Youngstown quite broadly. And it basically says, if we can find something in the congressional history, a practice, a long chain of practices that supports this action, the courts will not second guess it. That may not be a faithful reading of Youngstown, but that is what these two jokers came up with. I love that tie, by the way. Okay. There's actually, if you listen to the Nixon White House tapes, Nixon always make fun of him. He's like, wow, what did Nixon call him? He had a nickname for him, Sideburns or something. He had a nickname for Rehnquist because he always looked so funky. Anything else? Yes, sir.
Why do you think they go against kind of conventional logic? Because I'm sitting here thinking, even in both cases, if I continue to ask someone to do something and they don't say anything, I'm assuming that they're not going to do it.
Are you talking about Congress?
Yeah, I'm assuming that it's not going to happen, as opposed to thinking here was like, well,
this rewards laziness, doesn't it? This rewards Congress sitting on its butt and not taking controversial positions. Because here now Congress doesn't need to take a difficult vote on suspending the lawsuit to their constituents. These are companies. These are American companies. People work for them, right? This company lost a few $1 million from this lawsuit, right? Those are jobs. So this strategy eliminates the need for Congress to take controversial votes. Much of this entire acquiescence argument makes Congress not fit the bill. Because think about it, would Congress want to vote to not let the president take the steel mills? They'll rather sit quiet and do nothing. Congress likes doing nothing, so they don't have to take controversial votes. And that's, I think, maybe what happened here.
Last question, when you combine that incentive, when we're talking about separation of powers, and you combine the incentive to stay in office and not lose votes, with the president's ability to take leaps because there's a fixed time, does that unequal some of that?
The president's a fixed time is 8 years, 4 to 8 years.
That's what I'm saying. The president has a fixed time. He's got nothing to lose in taking leaps.
This is what Justice Scalia said in Noel Canning. And he makes this point very clearly. In any long-term struggle between the executive and Congress, who's going to win?
I can see two sides of it.
No, you can't. In any long-term struggle, not between a given president, George Bush, Barack Obama, the office of the president against the Congress, who's going to win any longer? No, the president. Think about it. You have 500 members of Congress petty bickering on stupid stuff. Each executive has the same damn focus, expand my power. From Clinton in Yugoslavia to Bush in Afghanistan, Iraq, now to Obama with ISIS. Every subsequent president expands the power of his predecessor. Congress is just helpless, pawing, right? And when Congress sits there and stays silent, doesn't vote, that's when they abdicate their power. Which is a perfect segue to the discussion on ISIS. So I'll do a little shtick for this one. Thank you. So about a year ago, the president announced that we are going to be engaging in some sort of military action against a group. What are they called? Well, it depends who you ask. Some people call them the Islamic State. Some people call them the Islamic State of Iraq and Syria, or the Islamic State of Iraq and Levant. ISIS, ISIL, or the artist formerly known as ISIS. I don't know, whatever you want to call them, right? Did Congress ever give the president the authority to engage in hostilities against this organization, which has bases in Iraq and Syria? So here's the president's argument, right? Way back when, I'm sure all of you recall, in 2001, after 9/11, Congress voted for an authorization of force against Al-Qaeda. Anyone who aids and abets Al-Qaeda. And it's been on the basis of this authorization in 2001 that we've gone to Afghanistan and we've gone to other places to take out Al-Qaeda. Okay? Does the 2001 authorization give the president authority to go after ISIS? Well, there's a problem here. ISIS is not Al-Qaeda. Believe it or not, they hate each other. They're competing for the same terrorist pie. They're actually at war. Believe it or not, ISIS is so crazy, Al-Qaeda expelled them. Okay? Al-Qaeda basically expelled ISIS because they were nuts. And if you want to think about relativity, yeah, that's it. So how can it be that attacking Al-Qaeda is justified? I'm sorry, attacking ISIS is justified based on this. Well, Congress, in their infinite wisdom, told the president, you get to define who Al-Qaeda is. You, the president, get to define who Al-Qaeda is. And know what the president said? I swear these are the exact words. ISIS is the true inheritor of Osama bin Laden's legacy. ISIS is actually really Al-Qaeda. It's like fee simple, right? They got the entire thing. ISIS is the true inheritor of Osama bin Laden's legacy. And since Congress delegated the authority to the president to decide which groups is actually Al-Qaeda, the president can believe that ISIS is actually Al-Qaeda. Is that correct? No. Does it make sense? No. But Congress gave it up. Not different than the Curtiss-Wright case. They said, you can pick the countries in the Chaco War. That's not for us to decide. Second, in 2002, Congress authorized the use of force against Iraq to take out the Saddam Hussein regime. You may recall this. We had a war there, right? Whatever. The president says, okay, I will rely on the 2002 authorization against Iraq to go against ISIS. The problem is ISIS is also in a country called Syria, right? Syria is not Iraq. Okay, so we have these two authorizations, 2001 and 2002, which provide some basis of authority, although it's quite weak. So what happened? The president gets on TV and says, I don't need any further congressional vote. I don't need it. I have all the authority I need. What does Congress do? Absolutely nothing. Do they vote to defund the action? Of course not. Do they vote to pass a new authorization for force saying, here, you can go after ISIS for 5 years, then come back to us, or here we're going to define ISIS? They do nothing. So what happens when the president's relying on past statutes, Congress does nothing to stop him? Kevin, under the Dames and Moore framework, how should we understand the president's authority here? Congress did nothing to stop him. They didn't pass a new statute. We have these old statutes in the past that, kind of support it. Any problem here? No, why not?
They've had the opportunity to challenge them and to take that authority away from them, and they did nothing.
This is what we call acquiescence, right? And it kills me because this is a live issue that I'm living with. But Congress has effectively acquiesced to the president's unsupported, maybe supported actions against ISIS in other countries. So while once the president wanted to repeal the 2002 authorization for use of force against Iraq, he wanted to repeal it. No, not anymore. He's going to keep him playing out. And those are basically in effect forever, and they're not going anywhere. So now he can use the authorization we had against Al-Qaeda as a free-range license to attack any sort of group that poses a threat around the world. So when I said, I'll get you a second, when I said who wins in the struggle between the president and the Congress, president to president, I don't care if it's Hillary Clinton or Rick Santorum, whoever, they'll do the same thing, right? There's not going to be much of a difference. These sorts of things always inure to the president. Yeah, Brian.
You said any group in the world, and you're talking about civil wars in Africa,
Depending how broadly you define Al-Qaeda, this could reach pretty far. There's Al-Qaeda like Boko Haram and other groups in Africa, which conceivably could be lumped under the same umbrella.
They've applied allegiance to ISIS. So.
Yeah, Abu Bakr. I mean, there are groups in Africa like Boko Haram that remember they kidnapped, bring back our girls. Yeah, they're still there. They technically have affiliations to ISIS. So yes, hashtag doesn't do much. Yeah.
But when Congress passed the
slacktivism, as they call it.
it passed the statute on the act saying for Al-Qaeda, could it have been that they purposefully did it instead of calling it just, I guess,
Osama bin Laden's friends. Yeah.
or even just in general, just calling it terrorism because it's more towards foreign terrorists and these foreign non-governmental organizations that were fighting. So instead of putting a generic term as terrorist, then you could even confine the acts that happened in South Carolina that went in and shot the church as terrorism.
I mean, they haven't tried that yet, but maybe.
To kind of just.
Hasn't happened yet. Yes, sir, in the back.
So you basically use an authorization to attack. That's unless Congress.
Yeah, unless Congress has a backbone and actually passes a bill saying no. Right, and the president will probably veto that. Ain't that something, huh, Debbie?
So,
Like the way you'll veto the Iran override. Go for it.
so did he even have to go so far as to make the argument that ISIS came from the same nexus as Al-Qaeda, or it's just that Congress is silent, so he can do whatever he wants?
That may be a bridge too far, but he has said because I get to define who ISIS is, that's my determination as president.
Does he get to pick and choose, or just like be like I want?
Oh, we're still going after Al-Qaeda.
But I
It's
mean,
both.
like,
Yeah, it's not one or the other.
Coney, that guy from
Who?
Africa. Coney,
Oh yeah, that YouTube video, right?
I mean, could he just like I want to go after them? As Congress gets kind of.
Congress can do whatever it wants, but if it doesn't vote, nothing happens. Unless Congress votes on something, it's irrelevant. And the president can look to the lack of voting as support for his positions.
So is a smarter thing,
Go for it.
smarter thing just to defund them, which is probably even more.
He would veto that.
involved.
Oh yeah. So effectively, once you have this idea where you start taking action with that clear support, you can then veto any attempt to defund it. Yeah.
His name escapes me, but what's amazing is their offer drone strike on an American citizen.
Zarqawi. No,
That sounds like
Zawahiri. No, oh God, what tells his name? The U.S. citizen.
In Yemen?
Yeah, what's his name? I'm drawing a blank now, but yes.
that's kind of amazing.
Oh, Al-Aqwi. Anwar Al-Aqwi. Alwaki. Someone can check the spelling. Anwar Al-Aqwi. Yes, sir.
Yeah, the country's in a different emotional state too, 2001, 2002, after, 9/11 and all that. And I would probably 5 to 7, 10 years after, we wouldn't go back and do some of the same things we did. So for the president to still be, using something that the mindset of Americans has probably changed since that time, it's kind of ironic too.
Congress hasn't stepped in. Until Congress intervenes, nothing changes. And in fact, the claim of acquiescence that Congress is acquiescing grows year by year. We had an intervening election, right? And still nothing changed. Any other questions? I want to get to Korematsu. I'm sure we have enough time for that case, so it'll be a little bit more weighty. All right, so I want to play a video. It's a little bit long, but this is a video of propaganda. This is not a video from the United States, I'm sorry, from the Nazis. It's a video from the United States government. And if anyone watched before, hopefully this works. Too loud?
When the Japanese attacked Pearl Harbor, our west coast became a potential combat zone. Living in that zone were more than 100,000 persons of Japanese ancestry, 2/3 of them American citizens, 1/3 aliens. We knew that some among them were potentially dangerous, but no one knew what would happen among this concentrated population if Japanese forces should try to invade our shores. Military authorities therefore determined that all of them, citizens and aliens alike, would have to move. This picture tells how the mass migration was accomplished. Neither the Army nor the War Relocation Authority relished the idea of taking men, women, and children from their homes, their shops, and their farms. So the military and civilian agencies alike determined to do the job as a democracy should, with real consideration for the people involved. First attention was given to the problems of sabotage and espionage. Now, here at San Francisco, for example, convoys were being made up within sight of possible Axis agents. There were more Japanese in Los Angeles than in any other area. In nearby San Pedro, houses and hotels, occupied almost exclusively by Japanese, were within a stone's throw of a naval airbase, shipyards, oil wells. Japanese fishermen had every opportunity to watch the movement of our ships. Japanese farmers were living close to vital aircraft plants. So as a first step, all Japanese were required to move from critical areas such as these. But of course, this limited evacuation was a solution to only part of the problem. The larger problem, the uncertainty of what would happen among these people in case of a Japanese invasion, still remained. That is why the commanding general of the Western Defense Command determined that all Japanese within the coastal areas should move inland. Immediately, the Army began mapping evacuation areas and for a time encouraged the Japanese to leave voluntarily. The trouble for the voluntary evacuees soon threatened in their new locations. So the program was quickly put on a planned and protected basis. Thereafter, the American citizen Japanese and Japanese aliens made plans in accordance with orders. Notices were posted. All persons of Japanese descent were required to register. They gathered in their own churches and schools, and the Japanese themselves cheerfully handled the enormous paperwork involved in the migration.
Look how happy they are.
Civilian physicians made preliminary medical examinations. Government agencies helped in 100 ways. They helped the evacuees find tenants for their farms. They helped businessmen lease, sell, or store their property.
It's a forced seller.
This aid was financed by the government. The quick disposal of property often involved financial sacrifice for the evacuees. Now the actual migration got underway.
Migration.
The Army provided fleets of vans to transport household belongings.
No rail cars.
And buses to move the people to assembly centers. The evacuees cooperated wholeheartedly. The many loyal among them felt that this was a sacrifice they could make in behalf of America's war effort. In small towns as well as large, up and down the coast, the moving continued. Behind them, they left shops and homes they had occupied for many years. Their fishing fleets were impounded and left under guard. Now they were taken to racetracks and fairgrounds where the Army almost overnight had built assembly centers. They lived here until new pioneer communities could be completed on federally owned lands in the interior. Santa Anita Racetrack, for example, suddenly became a community of about 17,000 persons. The Army provided housing and plenty of healthful, nourishing food for all. The residents of the new community set about developing a way of life as nearly normal as possible. They held church services, Protestant, Catholic, and Buddhist. They issued their own newspaper, organized nursery schools, and some made camouflage nets for the United States Army. Meanwhile, in Arizona, Utah, Colorado, Wyoming, and elsewhere, quarters were being built where they would have an opportunity to work, more space in which to live. When word came that these new homes were ready, the final movement began. At each relocation center, evacuees were met by an advanced contingent of Japanese who had arrived some days earlier and who now acted as guides. Naturally, the newcomers looked about with some curiosity. They were in a new area, on land that was raw, untamed, but full of opportunity. Here they would build schools, educate their children, reclaim the desert.
Reclaim the desert.
Their own physicians took precautions to guard against epidemics. They opened advanced Americanization classes for college students, who in turn would instruct other groups. They made a rough beginning of self-government, for while the Army would guard the outer limits of each area, community life and security within were largely up to the Japanese themselves. They immediately saw the need for developing civic leaders. At weekly community meetings, citations were given to the block leaders who had worked most diligently. Special emphasis was put on the health and care of these American children of Japanese descent. Their parents, most of whom are American citizens, and their grandparents, who are aliens, immediately wanted to go to work. At Manzanar, they built a lath house and began rooting guayuli cuttings. The plants, when mature, will add to our rubber supply. At Parker, they undertook the irrigation of fertile desert lands. Meanwhile, in areas away from the coast and under appropriate safeguards, many were permitted to enter private employment, particularly to work in sugar beet fields where labor was badly needed. Now, this brief picture is actually the prologue to a story that is yet to be told. The full story will begin to unfold when the raw lands of the desert turn green, when all adult hands are at productive work on public lands or in private employment. It will be fully told only when circumstances permit the loyal American citizens once again to enjoy the freedom we in this country cherish, and when the disloyal, we hope, have left this country for good. In the meantime, we are setting a standard for the rest of the world in the treatment of people who may have loyalties to an enemy nation. We are protecting ourselves without violating the principles of Christian decency. We won't change this fundamental decency no matter what our enemies do. But of course, we hope most earnestly that our example will influence the Axis powers in their treatment of Americans who fall into their hands.
Right? I don't show videos in this class often, but that one I actually give 10 minutes for because it's, I think it does a very important job of explaining what was at stake in Korematsu as well as Hirabayashi and Endo. So that video was propaganda, and the last 30 seconds make that clear. They said, we hope our enemies treat our prisoners of war in the same way. You know, we had people abroad who were also being captured, so they were hoping that would happen, and we don't violate our Christian decency. So what happened, right? Well, in 1942, roughly a year after Pearl Harbor, there were these various media reports that Japanese Americans were engaging in espionage, basically spying, subversive activity to try and harm the American homeland. And President Roosevelt issued what was known as Executive Order 9066. I have a picture of it somewhere. I don't. Executive Order 9066. And the purpose of which was to effectively remove all Japanese American people of Japanese ancestry from the West Coast. And this doesn't just mean people who are Japanese or who are the sons of Japanese. This is 1/116th Japanese. Basically, if your great-great-grandparent was Japanese, you were removed. Okay? Yeah. 1/116th, you were removed. Yeah. So basically, everyone. And the removal took 3 different phases. I want to make sure I make this clear. Korematsu was not the only case. In fact, it was the last case in the trilogy. The first one was Hirabayashi. Hirabayashi, okay? Hirabayashi involved a curfew. What do I mean by that? One of the first steps that the government took was to impose a curfew for all Japanese Americans, that they could not be out at night. Okay? In other words, they couldn't leave their homes. The second case we have now is Korematsu. Korematsu refers to the exclusion. That is, Japanese people could not be in certain areas. So I want you to think about this, right? One says you have to stay in your home. The other one says you can't be in this area. Everyone see the problem, right? You can't be in your home, but you have to stay in your home. So the only place they were allowed to go, and they show this in the video, were the so-called assembly centers. Remember they said the racetrack had 17,000 houses built on it? Basically, the only place that you can go is the assembly center. And once you were in the assembly center, okay, then that comes to the final case, which was detention, which was the ex parte endo. Okay, so it was basically 3 phases, not all at once, and the actual distinction, because the Korematsu case splits them up, which is dubious. But the first one was saying curfew, right? You have to stay at home at night. The second one said you cannot be in this area. So if you can't be in your house and you can't be in this area, the only place to go is the assembly centers, at which point they detain you because why? You can't go back to your house. You see, they layered one on top of the next. I'm oversimplifying significantly, but just to give you the gist of what happened. So I have a number of pictures that I want to show you guys. This is something which perhaps people today don't appreciate, but there was severe racism against Asians in this country, or in the 1800s, in the 1900s as well, especially after the war. It's not known today, but especially on the West Coast, there was a fear of Chinese people, particularly, coming and taking jobs. You're sensing a pattern. It's a very familiar one, and it's not new. So you see a headline. This is a San Francisco newspaper, The Examiner. Ouster of all Japs in California near, like, we can't wait, right? It's not like, oh my God, they're going to be ousted. It's like, oh man, it's almost here, right? This is a picture of one of the temporary camps that were set up. Here, let me show you this picture. This is a map of all the different places where they had the so-called assembly centers and relocation centers. They're concentration camps. So they had all these assembly centers on the West Coast, and then they sent people to the heartland, right? There were actually facilities in Texas. To show they're actually somewhere in D.C., so it's sent them all over the country. But they were mostly in the desert, middle of freaking nowhere, right? This is where these people were sent. Okay. If this was like Auschwitz, barbed wire fence keeping people in. There's another photograph being turned Japanese. That propaganda movie was quite good at making it look all hospitable, but it frankly wasn't. Here's a picture of Americans being rounded up, being brought to the Utah desert. Speaking of President Roosevelt, here's his wife, Eleanor, touring an internment camp. Everyone looks so happy and smiling. She's just having a ball there, isn't she? Yeah. Here's a picture actually of the Fred Korematsu and Hirabayashi, who are among the people in the case. Here's a picture. It's kind of cool of Korematsu and Rosa Parks, right? You gotta hang out with the cool people. Korematsu was given an apology and a reparations check. So you can see he's holding a treasury note there. He was actually given a check to compensate him for his loss, whatever the hell that is, right? But in 1984, a court actually vacated his indictment. It was mentioned in the opinion, and President Clinton gave him the Medal of Freedom in 1998. Korematsu died in 2005. And that's a picture of Mr. Hirabayashi, and that's Matsui Endo. She was the other plaintiff involved. So let's try to. Oh, and this is what I want to show you. This was the sign. So them nailing it onto the wall. This was the sign that was posted all throughout the West Coast, and I'll read it if you can. It says, instructions to all persons of Japanese ancestry living in the following area. Basically, in tiny little print, you can't be here. Show up at these places by this date, or else you'll be arrested. So effectively, they were put in this position where if they didn't comply with orders, they were arrested. And if they showed up, then they were relocated. Okay? This case made it to the Supreme Court because Mr. Korematsu refused to be relocated, and he was arrested. And because he was arrested, he got into court. Had he been relocated, it's not clear if he would have had access to a lawyer. In other words, the only reason this one made it to court was because he refused to comply with the expulsion order, which was a significant fact. I mean, he was putting himself at risk. He went to jail, right? He actually was in jail for this. So it goes to the Supreme Court. The year is 1940, was it 42 or whatever, 43. The United States government, was it 43? 43? 44, thank you. 1944. The United States government submits declarations to the court. Serious, right. And the declaration says, we have reports of Japanese Americans who are engaged in sabotage and are trying to harm American interests. You're a judge. I think it was up to, Brian, it was up to you?
Yeah.
Brian, you're a judge. You're a justice in the Supreme Court. The year is 1944. We're about to drop a nuclear bomb on Japan. Things are getting pretty testy there, right? The government comes to you and says, we have reports that a significant number of Japanese Americans are engaged in sabotage. And we can't tell which are good ones and which are the bad ones. What do you say to that?
And I don't question the acts of the government.
So you're a justice, you would have voted with the majority. I'm not saying you personally, but
At that time,
at that time, why? Why at that time do you think you would have done that?
because I mean, I'm sure most of them felt there was no other way or they didn't have any other options. And I mean, it's the government telling you to do it. So it's kind of a good thing.
How do you, and I want you realistic, actually put your, defending your justice in 1944, where in the midst of war, men are dying overseas. I mean, how do you handle that when the government tells you we have suspicions of sabotage among Japanese Americans?
I think they would have weighed the risk of it being higher than the loss of liberty, and I think that's why they would have.
I'm asking what you would have done.
Oh, what I would have done?
And be honest, I mean, it's not,
I like to think I would have voted against it.
but you like the thing. Yeah.
Well, but I mean, like 2015, if it happened right now, absolutely, I would have against it. In 1940s.
Let me ask you the more difficult question, right? Let me ask you this, Jennifer. What would the opinion look like? You're writing, say it was a 5-4, and then your vote flipped the case, right? What would your majority opinion look like, seeing the president loses? What standard would you have drawn? How would you have actually written an opinion saying that the court will not accept your interpretations? Yeah.
I probably would have drawn from civil war, from Reconstruction, the ideas of liberty, treating everyone equally, of
Yeah, but to answer this specific question, the government comes to you and says, if you let these people go, Americans will die from sabotage. What does your majority opinion say? And I want to be sincere. It's not an easy question, and I grapple with this every time I teach a case. What does your majority decision say when the government says, if you let these people go, Americans will die?
I would say something to the effect that you have the benefit, I mean, the risk. You have to go with the risk.
So you're willing to let people die to let these guys out? It's not. I'm not.
Yeah,
figuring,
well,
it's not
I
an easy question.
But I think
men are already dying for the cause of liberty. People are already dying for the cause of liberty. And if you suspend liberty to save liberty, you cancel yourself out.
Mary, what do you think?
I really like Justice Murphy's, and I think that aligns with what I would have, what my thought process is the reasonableness of the request to the surrounding situation.
Yeah, but how are you a judge? You're not a general. How can you possibly assess what's reasonable in this circumstance?
Because to consider that out of the number of people that they were removing, or the areas that were being removed, I would try to see the danger. I mean, again, although I'm not a general, at this point, I'm also not a judge looking over it. But
I'm asking, that's what the judge.
If I guess just, you can't give in liberty out of fear of.
And then Nuri, what happens if they let the Japanese go and a couple of people start blowing up San Francisco?
I'm probably
No, but that's the issue, right? It's one thing where the government does something and the courts don't get involved, but this case came to the courts because Korematsu filed an appeal. You have to do something.
Well, I mean, a couple of things. One, I mean, if we believe in the justice system at all, we believe in that the Constitution provides these liberties for American citizens, we have to side on, he's done nothing wrong. I mean, he has not, there's no reason to imprison him. He has not violated the law yet. And until then, until that actually.
Oh, he violated the law. He violated the proclamation that Roosevelt issued.
Yeah. But
Didn't Congress give him the authority to do so?
yeah.
And is it when Congress and the president agree, we assume that they're acting lawfully?
Well, we would assume so, but it's also our job, according to Marshall, to have oversight of that, to have the power of review.
But didn't
that's
Jackson?
not being reviewed.
But didn't Jackson say a couple of years later that when the president gets the authority stripped from Congress? I mean, we're talking in a time of war against our enemies with a statute. He's at the zenith of authority. How do we? You're a judge. How do you write an opinion where the government says people will die if we don't do this? Well, pretend you are. Fictional court. Pretend you are.
I mean, honestly, I feel that a lot of what the dissent said is true because I don't really remember the exact history during that time, and I'm not a
General, yeah.
as a general. So to me, it doesn't make sense that you can exclude hundreds of thousands of people based off of small pockets of possible espionage, possible sabotage. So to me, the bigger picture is: are we going to maintain the liberty of these American citizens because they are, or are we going to say, well, the small possibility of some type of explosion or bomb threat? To me, it doesn't really make sense that you would put one citizen's liberty over another.
Okay. So I think, and I'll move on a little bit, but what you're all conveying, I think, is how the dissents read the case. And it's really easy to read the dissents as being awesome. And I personally probably would agree with them. But you have to remember what's being told to the court. And this isn't like Youngstown where we're talking about things domestic. Here, the threat was at home, right? The threat was on our shores. Now, let me tell you what actually happened, right? They were lies, okay? The rumors, to the extent they existed, were basically not true. In fact, in the Solicitor General's office, the Solicitor General is the top government lawyer, right, who argues for the court. They basically fought with the DOD, I suppose the War Department at the time, over what to include. And basically the president and government said to the Solicitor General, you need to put these arguments in. They were false. Decades later, I think in 2011, the Solicitor General filed a letter with the Supreme Court apologizing, saying that we misrepresented to the Supreme Court. It's very often the case when the government comes in and they says, if you don't do this, people will die. What happened in Youngstown? The same argument, right? And in many respects, this opinion Justice Black wrote the majority in this case. He wrote the majority in Youngstown. This maybe was his comeuppance, right? Saying, I screwed up in Korematsu, let's stick it to Truman, right? In the Guantanamo case, which I will not even teach because they don't really matter anymore, but the argument was made very similarly. If we don't withhold these people at Guantanamo and let them go, they will return to the battlefield and kill Americans. Justice Scalia's dissent in one of the Guantanamo cases says it very bluntly. He says basically, because of the court's ruling, people will die. He says it without any, without any caveats. And he's not necessarily wrong. A lot of the people released from Guantanamo did go back to the battlefield. It's a complicated issue. But this case isn't so easily resolved because of the simple fact that there are American lives at risk. Now, the majority opinion by Justice Black touches on a lot of areas. And I can teach this class in a couple different spots. So you probably thought this case was an equal protection case, right? Why? The government made a classification on the basis of race. They said, if you are of big letters, Japanese ancestry, right, we're going to detain you. Was this a classification on the basis of race? What did the majority say, Elizabeth? What was this a classification on the basis of race? Not Justice Murphy. What did the majority say? What were the government trying to exclude? Were they trying to exclude Japanese people, or what were they actually saying they were trying to exclude, Elizabeth? Yes, exactly right. The government said, we're not excluding people because they're Japanese. We want to exclude disloyal people. So, Elizabeth, why couldn't they just check if people were loyal, ask them to take an oath to the Constitution? Why did they have to have a massive exclusion? What's the government, the majority, how does the majority defend it? Basically, yeah. The government said, we don't have time. We're in the middle of a war. We don't have time to give an oath to everyone else. So we're just going to round them up and throw them in camps in Utah and have them build houses and, make newspapers and stuff, right? It doesn't pass the smell test, right? It doesn't pass the laugh test. But, let's see. But Andrew, is the court willing to scrutinize that justification? Are they willing to second guess the government and say, no. If you want to do this, give a loyalty test. Why aren't they going to scrutinize a classification on the basis of race?
Because they will show that they don't agree with them.
What's overriding the interest, right? What, classification on the basis of race or bad, what's overriding that interest here? What's at stake here?
Would it be that they're at war?
National security, right? So the argument's like this. The court doesn't say that racial discrimination is okay. In fact, they kind of hint that it's bad. But they say, this is too important. The compelling interest of war is so significant that it will allow the government to make a broad classification on the basis of race. In other words, we will let them violate equal protection because national security is so important. Everyone get that? So they go past the ancestry part very easily. And they say, usually you can't make it. They say all restrictions which curtail rights to a single racial group are immediately suspect, right? We're suspicious about classifications on the basis of race. We subject to them to the most rigid scrutiny. But pressing public necessity may sometimes justify the existence of the restrictions. Let me say it again. Pressing public necessity may sometimes justify the existence of such restrictions. This is what we'll be discussing for about a month called scrutiny. The idea that when the government makes a classification on the basis of race, they need a really damn good reason to make that classification. In our Supreme Court history, there have been 2 cases where the Supreme Court has upheld the use of race as a classification. One is Korematsu. Anybody know the second one? The Michigan affirmative action cases, right? So what are the most compelling interests that can justify racial discrimination? The court said, Korematsu and affirmative action. There you go. We'll do that in about a month. But they say compelling interest, national security is so important, it can override the fact that you're making a racial classification. But then they move past the race issue, which really takes up a paragraph. They don't dwell on that for particularly long. And they try very hard, Clint, to separate the curfew from the exclusion, the detention, right? Why are they trying so hard to separate those items?
Show that there is a difference in each instance.
Give me more. You're on the right track.
They just wanted to emphasize that this is a time of war, and that it calls for a different type of judgment for what they're wanting to justify.
Well, Clint, let me ask you this, right? Would a curfew by itself seem that bad?
No.
Would an order saying that you can't be in a certain area seem that bad by itself? Worse, but what happens when you couple that with the saying, well, if you can't be in your house and you can't be in the West Coast, we're going to move you to a desert in Utah.
That seems bad.
So by separating each element, the court was able to uphold it more easily by saying, okay, look, this is kind of like a curfew. They're saying you can't be in California. Okay, then go to Arizona, right? But what the court is willfully ignoring, this is indeed willful blindness, is they're not going to Arizona by themselves. They're being put on a car, a rail car, and being schlepped to the concentration camps. Everyone understand that? So by separating it, they're able to make this less bad. And also they're going to try to avoid setting a precedent of saying that all of this is okay. Because this is mentioned in the notes, Iris. What happened in the case of ex parte endo, the case about detention? What happened to ex parte endo? This was the case of whether Ms. Matsui Endo could be detained. Yeah, I mean, it's in the notes after the case. The ones that you should read. Anybody have it? Endo. No? Was it not in the notes? I thought it was. Is it? Note 4. What does note 4 say?
That it was a habeas corpus challenge?
Yes. So what happened ex parte endo? Note 4. Everyone's reading it now.
It was not authorized by statute.
Yes, ma'am. Yes, ma'am. Thank you, Iris. In ex parte endo, the court said that the president could not detain people. So think about it. They upheld the curfew, they upheld the exclusion, but they invalidated the detention, right? Taylor, what does that mean when you uphold the curfew, uphold the exclusion, but invalidate the detention? What happens to the entire regime?
Was it that they could no longer be in those concentration camps? Because
Yeah.
that was essentially.
How did they get? The only reason they were in the camps was because they couldn't be in their home country, their home state. You see what happened, right? They upheld the curfew, they upheld the exclusion, but they didn't uphold the detention. The only reason they were in the detention area was because they couldn't be in their houses, right? So it's this weird dynamic where they upheld the president's most glaring powers, but they invalidated the most serious one, right? And what they said in endo, which I didn't assign, is that basically the president needs to give a loyalty test to decide if someone can actually be detained, right? You can't detain someone without having that sort of loyalty test. So even though the majority opinion upheld the exclusion, by invalidating the detention, what's the government going to do? Where are they going to send these people? They can't put them in a camp somewhere, so they have to leave them at home. So it was this weird way of splitting the difference, right? They basically sanctioned the president's power to exclude, but not his power to detain. Because he couldn't detain them, they had to leave them at home. Everyone see what happened there? It was very weird. And I'll give you one more. I think this is mentioned somewhere else, but one of the justices tipped off Roosevelt that they were going to vote against him. So Roosevelt said, okay, fine, I'm going to close the camps anyway. So even though this case came out in December, about 3 weeks later in January, he shut down all the camps. So all of this was largely unnecessary. Right? It was unnecessary because he was going to shut down the camps anyway. But because the court sanctioned this, they put their blessing on this. Now this is constitutional law. And future presidents, in the words of Justice Jackson, can pick up that loaded gun and use it.
You're saying the steps they took were unnecessary, or you're saying
The decision itself was unnecessary. If Roosevelt was going to shut down the camps, they didn't need to decide this case. But as Justice Jackson said, by deciding it, they've now put the Supreme Court's blessing on this sort of broad executive power. They've handed to a future president a loaded gun. And in fact, as it turned out, there was a very big debate within the Bush White House of whether they could cite Korematsu during the Guantanamo cases as a favorable precedent. The court won't cite it, but when the government lawyers cite it, I think they ultimately did not because it's considered such a wrong precedent. But there was a big debate because it provides a very good precedent for locking people up. The Supreme Court still hasn't repudiated it officially. Yes?
Well, I guess the FBI was tipped off that the court was going to decide against him, so really it was necessary to say.
Ah, that's the other way of looking at it, right? What if the court would have said, hey, Roosevelt, shut it down or rule against you? Rather than, we're ruling against you, so shut it down. See, the order which came first, the chicken or the egg. Okay? So the court upheld it in very, very gross language. And if it was jarring and difficult to read, you have a soul. Basically says, listen, there's hardship by war, right? We have rationing, we have different things. This is just a hardship of war that some people have to endure. And they even said, let's not call these concentration camps because of the connotation. You know, obviously talking about the Nazi concentration camps. Okay? And they close like this. We cannot have the hindsight, right? We don't know today whether our actions are unjustified, and we're not going to be in a place to second guess the government. Basically, listen, we're not going to second guess them. We don't know enough to do it. All of you think you might be generals, but the court said they're not. Yes, ma'am.
So, if the court really felt like this was in the interest of national security, did Jackson bring up why aren't they rounding up all Germans?
Oh, yes, okay. I was going to make that point, but we had several enemies during World War II. We had the Japanese, we had the Germans, and we had the Italians. Also, we had several other countries aligned. We weren't excluding into camps the Germans and the Italians. Jackson's basically calling BS, saying, listen, this didn't happen right after Pearl Harbor. This happened significantly later, right? This is not happening against the other groups. Jackson's like, this is born of racism. And that's what Justice Murphy says as well. This is born of racism and bigotry. And there's really no way to justify it. The three dissents by Roberts, Murphy, and Jackson, the case was 6-3, make a number of points which are important. But one of which I want to stress is, by issuing this decision, the court has just blessed this species of executive power and has now made this possible for future presidents to engage in this sort of action. And whenever the court sanctions something, that's what's most dangerous, because if you're an executive branch lawyer and they approve this, you think you can do anything you want. So let me ask you, if you were advising President Truman and Korematsu is in the books, hey, can I seize the steel mills? Well, you can seize Japanese Americans. Of course you can take the steel mills, right? Was this crazy? This is why Youngstown is obviously is a repudiation of this decision, because it's like, woo! And in fact, black wrote the majority in both cases. Okay? Justice Murphy says this is the ugly abyss of racism, which is a very powerful phrase. At this point, my friends, Plessy versus Ferguson was still good law. I mean, we often think of it. Brown was not 2 decades away. Plessy was still good law. And the government had basically said you can discriminate on the basis of race and, you know, equal accommodation. So I suppose those pioneer camps were quite equal. And then closing it out was, of course, our friend Justice Jackson, who, as Michelle mentioned, takes a very direct attack, saying that even in the times of war, we shouldn't be so deferential. And remind you, he had been a lawyer for President Roosevelt for a number of years. He had probably known, not about this, he knew about the details of these sorts of plans, but he pushed back. Yeah.
I thought there were
Not on this scale, and they were able to take loyalty oaths to exclude. In fact, there was a case I didn't assign, but is in your book called Ex parte Kieran, which was a Nazi saboteur case. So there were actually these Nazis who washed up on the shores of Florida and were captured. I didn't assign that case, but that's a fascinating one. Basically, FDR put them on a trial in the Justice Department without any real judges. And the Supreme Court basically was asked whether they can try them without real judges. And the decision came out after Roosevelt already executed them. This was a crazy time. If you want to read it, it's in your book, Ex parte Kieran. I removed it this year because I had too much other stuff to read. But those were crazy times. The types of things that Roosevelt did are frankly scary. His admiration is well undeserved. Yes, sir.
Just as an aside, discussing with my wife, she's Costa Rican. They actually did inter Germans, because there was a huge German population in Costa Rica in World War II. They did the exact same thing we did to the Japanese. Their property was sold, their homes were gone, their businesses were seized, and they were shipped well. But
yeah, they did that in Germany
not the
too.
Desert, but
yeah,
the jungle.
Yeah.
So it was not an uncommon thing.
Okay. So any other questions? This is a very difficult case to teach because it seems so implicitly wrong, but I hope you can at least put yourselves in the mind frame of what was going on at the time and how they decided it. Ultimately, if you want to know what the reparation amount was, each person who was a survivor got $20,000 for being locked up in 1980 something dollars. Yeah. Okay. Any other questions? Please be sure to read all of Zivotofsky. It's a very important case for next week. Have a great week, everyone. Thank you.
Wednesday, right?
Wednesday.